So good morning, everybody. This is the Rules Committee. And I guess our agenda here is that we've got the minutes of the January 2 meeting, 2020 minutes. And what I'd like to do is there a motion to approve those minutes?
So move.
All right, second?
Second.
All right, all in favor?
Aye.
Aye.
All right. So any opposed? All right, so the minutes are approved. So Elizabeth, you want to tell us about, we have a referral from the Rules Committee, which is what's prompted us to have our meeting today.
Yes, we do. So and thank you all for joining. I appreciate it. The Rules Committee of Superior Court has received a request from an attorney to broaden the minimum continuing legal education rule. We do allow attorneys to get up to 4 credits of CLE for mock trials. We restricted that, though, to law school mock trials, and the request is that we brought in the term to include scholastic and collegiate mock trials as well. So the request, it does come through the Connecticut Bar Association, and again, their request is to broaden that term from mock trials at ABA-approved law schools to mock trials that are also scholastic and collegiate. It looked to me, though, that they were willing to go all the way down to middle school for mock trials that would get credit. And so I did an analysis for you. We had looked at the mock trial rule because originally the MCLE rule was written without any mock trial support. Right. And we had determined that we would like to offer that as an option up for a certain number of credits. At the time, though, our bright line test was whether it was a law school competition. And the reasoning behind that was that the law students are getting a similar education when they become lawyers. So the education they get credit for is similar to what a lawyer would get in a legal education setting, and that we weren't sure that a high school or college level tournament would have that same level of vigor to meet the content requirement of the rule. Separately from that, we're also a self-certifying state, which means that when this rule came into place, we did not add any judicial branch resources to it. So most states approve CLE specifically course by course. They get applications that come in, they charge a fee for that, and then they approve a specific course of conduct. And so this commission has instead looked to make bright line tests so that we can say this is definitively within the category, this is not within the category. Our rule is very broadly written. It's very easy for attorneys to do their CLE, and the judicial branch has offered, we have 75 podcasts right now that are free continuing legal education. The risk, it's a wonderful idea to participate in these trials, so I don't want to sound negative that this isn't a worthy civic endeavor. The risk, though, is that once you allow civic endeavors to become a substitute for legal education, you will get more requests. And I did do a survey. I looked at what other states do. Quite a few states do allow pro bono work, which again, it's nice for attorneys to do pro bono work. I think we all encourage it, and it's sort of part of the civic responsibility of being a lawyer is to participate in society. But we have not allowed pro bono. So I guarantee you, if you recommend this, the next thing that will come to you is, can pro bono work count? But I also looked, and there are states that allow sitting on judicial branch commissions like this one to count for your CLE credit. And there was a state that allowed election watching, so watching the polls, to be a CLE credit. And the risk is just that it becomes more of a broad civic term rather than a legal education rule. So that was the recommendation from us, was that you restrict it to the law school. I think you're within the reasonable standard of what most states are doing, including the model rule, which doesn't allow for any moot court competition. And the Rhode Island rule they referred to only allows 1 CLE credit, and the New York rule also has similar restrictions. So that's the law as I see it, but it's really up to the committee to make a recommendation to the Rules Committee about it.
So I can speak to this, in that we had this before us a number of years ago, and the concern was that, at least with law school, we felt that there was some rigor that went along with that, and that's why that was my recollection of this conversation that we had a number of years ago. And the other thing that is that we don't, which is, which was very purposefully when we passed this rule, don't have a part of the judicial branch or another department that looks at all the different courses that would look at to see whether a collegiate event should be approved. Whereas New York, I believe, does, and I'm not sure whether Rhode Island does or doesn't have a commission that looks at that. So I am inclined to leave it the way it is, but I'd like to hear what everybody else has to say about this.
I guess I'll just comment that I have been a coach both at the middle school level as well as the undergraduate university level at University of New Haven. There's a big difference also between the level of preparation and teamwork and competition that goes into these particular mock trials based upon whether or not it actually satisfies credit for an ABA approved class in a pre-law program. So we don't have many of those here in the state of Connecticut, and that's why I'm throwing that out there. So I think that perhaps if you had a carved out situation, maybe that would apply because that would be very similar to a law school. I've also coached law school mock trials, but I think that would be similar in nature. I can speak from personal experience that middle school coaching and judging is nothing like law school coaching and judging. So there is quite a difference in the amount of preparation, the seriousness of the applicability of the rules and stuff of that nature. So I also am in favor of having it stay the way that it is and restrict it to the law school setting.
Yeah, this is Rosemary, and I am also echoing your sentiments, having just finished the curriculum on our law school mock trial class. The students are going to be competing in the next couple days, and I would also add that the rule, in addition to the rigor of the law school, our rule is really designed for a focus on educating the lawyer, or making sure the lawyer is being educated. And in addition to the distinction between law school level and a lower level, there's also the distinction between coaching and judging,
yes.
Which, the judging is a far lesser involvement. So I think we should keep the rule where we have it.
In the interest of transparency, well, first, I want to welcome back this wonderful group. I mean, it's been a few years. I mean, great to see the smiles, Your Honor, and Lou, Fred, Rosemary, great to see you all. In the interest of transparency, I am a member of the CBA group and the civics committee that's proffering this proposal. So, I will abstain from the vote, but I just wanted to provide a little more background in terms of the substance of what the request is. They are looking for up to 4 credits per year, which I believe is a little rich based on how we've looked and judged these other aspects or these other previous proposals that we had. The opinion that we already decided that Fred referenced was opinion 3. And that went back to December 21st, 2016, when the commission made that ruling. And the issue for this committee was really about delivery and content. And the ultimate decision was based on the content of the mock trials. The opinion 4 dealt with, that was an actual advisor attorney to a high school mock trial. And that one we turned down on both delivery and content. But opinion 3 on the mock trials, we did decide that from a law school perspective, those were acceptable for both delivery and content. Anything below that level is what we judged in terms of content not being sufficient. And to play contrarian, just, I've also judged at the high school and the college, the high school level for civics first. And these are, in terms of the content, I can't say that the information that's sent out and reviewed based on the level and the intricacies involved, there's federal rules of evidence that are followed. I can't say that they're disparate from other, educational opportunities that we would have. I know Elizabeth referenced the podcasts as being free avenues to obtain credit, and those are very good. I mean, the flip side of that is I was on a podcast and Mike Bowler did a great job of interviewing me, and I don't know how much educational content young lawyers got out of listening to me over a 4 series on the workers' comp expertise side. But the high school level, I think, is where we drew the line between high school, I should say between undergrad and law school, and Your Honor had referenced that the content even at the college level didn't meet we're calling it the, delivery and content, levels. I would abstain from that because I do think based on review, even at the high school level, comparative to what we see out on the educational level being offered, I think it is comparative. And I think it would also serve the purpose of getting more attorneys involved. So I think from both a content level and from a participation level, looking at the broader scope, I think those are ancillary issues to what our charge is here today. But I do think that they are of great benefit. And to Elizabeth's point, I don't know if there'd be a rush. I mean, we've been sitting here for 3 years without one inquiry. And, we've gotten this one now. I don't know if there'd be a rush by other groups to knock the doors down, but I would argue that that's our charge. I mean, if there are other inquiries by other groups and we need to meet them and deal with them on a case-by-case basis, I'm sure that this committee would be up to the task if that was the necessary byproduct of this decision.
And just to Lawrence's point, I would also just point out that the commission has issued opinions to lawyers who teach undergrad law classes, and they don't get any CLE credit for that. And so that's sort of the consistency of that approach. If we've told, look, if you're teaching paralegals, real estate law, you're preparing, you're doing substantial work to provide them with that education. And it's hard to say, well, somebody who coached a high school moot court competition can have credit for that, but somebody who's teaching, future paralegals or doing pre-law classes doesn't get any credit for that.
Elizabeth, this is Lou Pepe. Could you elaborate on the New York and Rhode Island rules, if you know, because they were referenced in the application from the CBA?
Yes. So in Rhode Island,
they do allow it, or could you? And I understand their structure may be different from ours in terms of certification of appropriate legal courses and the like. Or maybe you could shed some light if you haven't done that investigation. I understand.
So I referenced it in the memo, but in Rhode Island, they give 1 credit for it. It's not a substantial CLE credit for it. And the restriction is that if you're acting as a judge, there has to be a student critiquing aspect contribution to the competition. So you can't just sit and watch a moot court and make a decision. You have to give feedback to the people in the kids in the audience that participate in the matter. But again, it's restricted to 1 CLE credit a year. And then New York actually makes a distinction between high school and college competitions and law school competitions. There's a combination of no more than 6 credits, and that's over a 2-year period. So that's really 3 credits per year. And of that, only 3 of those credits over a biennial can be for high school and college competitions. So you're looking at 1.5 credits per year. So this would be a more generous ruling on that. And then I believe, I know I looked at a number of states, but frequently they're looking for you to do a number of hours before you even get a credit. So you're doing like 4 hours or 6 hours or something like that to even get a credit for doing this kind of competition. But both Rhode Island doesn't have a very vigorous rule, but there is still a sponsoring application aspect to it. But New York has quite a vigorous rule in terms of the person who runs the competition needs to apply for credit to get that status. So there is more oversight over the competition.
I understand. Thank you very much.
Sure. And I did look at, there was another state, Delaware. They did broaden the rule, but it's limited to the Delaware mock trial competition. So they just have one competition in the state that they have determined meets the qualifications. So just to Judge Murphy's point, that maybe if you wanted to make a carve out, if there was a particular program that you thought met the rigor, you could do a carve out like that.
Thank you very much.
Fred, did you want to take a vote on this?
Is anybody else want to make any comments?
You know, I have really nothing further to add, and my experience has been similar to Judge Murphy's as far as being a high school coach and also judging college level mock trial. You know, I'm pretty comfortable where the rule stands now, and you know, wouldn't be in favor of watering it down, at least not at this point. I'm not, you know, if there's something specific with respect to a rigorous college mock trial or process, maybe that's something that we can consider at some other time. Certainly, I would never consider anything before college, given my experience as a high school coach for mock trial. But it doesn't appear to be a specific competition that they're asking for a special exception. It's kind of broadly based. So I feel far more comfortable keeping the rule as it is as now.
Okay. Anybody else have any comments? All right. Do I have a motion on the floor well, I'll make a motion. Make a motion that we leave the rule as it is and don't make any changes changes that have been requested to broaden the rule. Is there
Second.
any
Second.
Second,
all those in
also
favor?
third. In favor.
Aye.
Aye,
Aye.
Judge
Aye.
Murphy.
Aye.
Okay.
Right.
All opposed? And the minutes should reflect that I know Larry
Yeah,
abstained.
abstain.
Thank you, Fred.
All right.
Could I just ask the committee, would it be okay with you if I draft something to send to the Rules Committee and show it to Fred and Judge Bizzuto and then provide that to the Rules Committee, or does the entire committee want to see the proposed comments to the Rules Committee?
I'm comfortable with your proposal to just send it to a few. Thank you.
Yes.
Is that okay?
Likewise.
Yes.
All right. All righty. So any other new business? Other than everybody needs to go, I guess, go to work here. So.
Yeah.
All right. Well, motion to adjourn.
So moved.
So moved. All right. Thank you very much, everybody.
Thanks,
I
everyone.
appreciate it.
Thank you. Have a
Thank
great
you.
day.
All right.
Thank
Have a
you.
great day. See you all.
Thank you.